Ebony Birchall, who will be speaking first tonight, is a lawyer at Slater and Gordon with a background in health law and human rights. She is currently working on a class action on behalf of asylum seekers detained on Manus Island. The action alleges that the Australian government and the contracted management companies with control of the centre have breached their duty of care to the detainees in respect of conditions at the centre, as well as the healthcare, food and water provided. Ebony is also a PhD student at the University of Wollongong. She is researching the experience and position of healthcare professionals in Australia's immigration detention centres and the legal and ethical conflicts those professionals encounter. So please welcome Ebony.
So tonight we're talking about the topic hiding child abuse in detention centres. So I thought it would be good to start by kind of unpacking that topic a little bit so we understand it more. So the first issue I wanted to address is the idea of child abuse in detention centres. So the very fact that Australia has detention centres is problematic. So as you probably all know, our country has a policy of mandatory detention, which means that all asylum seekers who enter Australia are detained. It is widely accepted among psychological experts that prolonged detention itself causes mental harm. So this is for both adults and children, and I know that tonight's topic really focuses on children, but it goes without saying that there are issues with adults being in mandatory detention as well. So firstly, detention is a negative socialisation experience, and detention exacerbates the impact of other traumas. And as you'll appreciate, people who are asylum seekers have traumatic backgrounds and pasts. So there was a study, one study done that estimates that the rate of suicidal behaviours among men and women in these Australian detention centres are approximately 41 and 26 times the national average, respectively. And furthermore, male refugee claimants in detention have rates of suicidal behaviour that are 1.8 times higher than male prison rates. So that's not males in the community, but male prisoners. Another study assessed parents and children who had been held in Australian immigration detention centres for approximately 2 years, and all of the individuals in that study met diagnostic criteria for at least one current psychiatric disorder. 26 disorders were identified among 14 adults, and 52 disorders were identified among 20 children. So on top of this generalised risk of psychological harm eventuating from prolonged detention, detention centres have proven also just to be dangerous places, especially for children. So the Forgotten Children report, which was prepared by the Australian Human Rights Commission, has provided a few statistics on that issue. So within about a year, there were 57 serious assaults. There were about 233 less serious assaults purely involving children. So that's not all assaults, that's just 233 assaults within a year involving children. And then 33 incidents of reported sexual assault, and the majority of those incidents involved children as well. So on top of those statistics, there is now evidence from sources such as Senate inquiries into Nauru and the Ross Review, which suggests that particularly in offshore regional processing centres, detainees are at a further risk of harm because of the staff of the centres or because of hostile native populations in those areas. So examples of that is an adolescent boy in November 2013 was touched inappropriately by a local cleaner, and then a 4-year-old girl was struck in the back of the head with such force by a Commonwealth contractor that she was propelled off her feet. Then a 10-year-old boy with special needs was struck across the face by a Commonwealth contractor. And another example, and I mean there are many, a Commonwealth contractor attempted to assault a child with a cricket bat on a school bus. So it's fairly clear that conditions in detention centres are dangerous and you could say abusive to children. So the most recent statistics I could find about how many children actually are in detention centres told me that there are currently 93 children held on Nauru, and about 104 children in detention within the Australian mainland. So that's sort of the child abuse sort of side of the topic. The other side of the topic that we're talking about tonight is this issue of secrecy and hiding what's actually going on within these detention centres. And more specifically, I wanted to address the recently introduced Border Force Act. So this was introduced on the 1st of July this year, and it was quite a controversial act when it came into force. In particular, Section 42 of that act, it was labelled secrecy. So the fact that it's labelled secrecy, I mean, it goes without saying, it seems a bit ridiculous. But the point of that provision, it basically says anyone who's worked within a detention centre is not allowed to disclose any information that they've received during the course of that employment. And if they do disclose any of that information, then they could be imprisoned for 2 years. So it makes it a criminal offence for anyone who's worked within a detention centre to disclose information. So this means current staff of the Department of Immigration, but also former staff, and it covers any disclosures after the 1st of July. And you'll note that the disclosure of the information itself is the crime, and that from a legal perspective is important because it means that it doesn't matter what information you're disclosing, it's just purely any disclosure that's made is illegal. Therefore, even if you were just talking to your spouse or your children about what's happened at work that day, that's illegal. So it's quite a broad provision. So this issue of secrecy is of particular relevance to medical professionals. So the medical profession has had a key health and public interest role in informing the community about what's actually happening in detention centres. So some examples of that is in November 2013, 15 doctors who had worked in the immigration centre on Christmas Island wrote a letter raising concerns for the welfare of detainees. And then in April this year, another letter was written from professionals from Nauru, which informed the community of things like sexual harassment and sexual assault of children. So you can see that health professionals play quite an important role in informing the community about what's actually happening within these centres. Most recently, I'm sure you've heard in the media only in the last week, there's about 1,000 doctors and nurses from Melbourne's Royal Children's Hospital which are processing children in detention centres. So again, you can see that health professionals have quite a key role in advocating for these people in detention centres. And there was quite a strong backlash from medical professionals to the Border Force Act when they came into force. And there were a few key reasons why medical professionals in particular are impacted by these secrecy provisions. So medical professionals have quite strong and detailed professional obligations, as you can all appreciate. I mean, the most basic one is that medical professionals should act in the best interest of their patients. And it's something that you would expect of your doctor, and it's quite understandable that doctors should be acting in the best interest of their patients at all times. And it's also important to realise that doctors working in detention centres can be subject personally to investigation for breaches of their professional obligations. So their personal reputation and their personal professional accreditation is at risk if they go outside of their professional obligations within that environment. So concerns have been emerging from healthcare professionals who work in detention centres because they've been asked to do things, undertake procedures that are actually against their professional obligations. So the government and the contracting companies that manage these detention centres have actually asked them to go outside their professional obligations to perform treatments that are against their professional obligations. So those concerns were so serious that a group of practitioners have been calling for a professional boycott of detention centres. So an article published in the Medical Journal of Australia last year actually said that the potential role of a professional boycott to motivate change should be openly discussed, and they called on the health professions, colleges and the AMA to lobby for effective change so that asylum seekers can receive appropriate care and so that those providing care within detention centres are not professionally compromised. So again, you can see that healthcare professionals do take on quite an advocacy role in these settings. And research has shown that practitioners in Australia's detention centres are affected by the ethical dilemma that they face working under this conflicting loyalty to their patient and then the employer, which is the government basically. So a study into the ethical responses of workers in detention centres reported this statement from a worker in an offshore centre. He said, "I wake up in the middle of the night in a cold sweat, worried that one day we may have to face a royal commission and have to answer for the conditions under which these people were treated and which we didn't have the guts to challenge the government on." It's also been recognised that medical practitioners who are working in these detention centres have no real autonomy to improve the level of care that they provide to their patients. So one way that doctors have been managing this conflict was by speaking out and advocating on behalf of their patient so that they could actually work for their patient's best interest. But these new secrecy laws put medical practitioners in an even more impossible position because this conflict of interest that they had between their patient and the government is now even further complicated because if they do speak out on behalf of their patient, then they're now threatened with criminal prosecution. So really the Border Force Act withdraws the last mechanism for medical practitioners to act on their best interests of their patients. So without the ability to advocate for their patients' best interests, some have even commented that a healthcare practitioner may be viewed as complicit in the mistreatment of their patient. So Dr. Marie Bismarck has queried whether in 5 or 10 years' time questions will be asked of health practitioners who may have been complicit in the mandatory detention regime, which is an interesting concept as well. Now, of course, there have been debates surrounding the veracity of this Border Force Act and what the intention of the laws actually were, because, of course, after all of these concerns came out from human rights advocates, the department really hit back against that and they made statements that these concerns from the human rights advocates weren't actually correct. So, for example, the Australian Border Force Commissioner said that the department and its service providers have robust internal policies, procedures and review mechanisms in place through which any concerns, including those related to medical treatment, can be raised and addressed. And he says that claims that these secrecy provisions will prevent individuals from speaking out are factually incorrect and highly misleading. So I guess against those sort of comments from the department, you have to look at the situations where, for example, the practitioners from Christmas Island who wrote the letter to the government back in November 2013, they wrote quite a detailed letter. From memory, it was about 90 pages long, and it detailed case studies and actual events that happened that needed to be rectified. And those practitioners never actually got a proper response to that letter. So you have to query the Commissioner's comments there about how robust their internal policies and procedures actually are. And if these healthcare practitioners can go to the government and raise their concerns and they're not getting any comments back from the government, or they're not actually aware of any progress to be made or improvements to the healthcare that people are receiving, then what other mechanisms do these practitioners have to try and address these human rights concerns? There's also been commentary that whistleblowers from within detention centres who wish to disclose information would be protected under the Public Interest Disclosure Act, which is sometimes referred to as whistleblowing laws. So there are a few issues with stating that these medical professionals should just rely on these whistleblowing laws. The first major concern is that if these practitioners have to rely on the whistleblowing laws, that means, of course, that the onus is on that health practitioner to prove their own innocence. So they are put to the legal task of defending their actions in disclosing information. Now, this is particularly concerning because the whistleblowing laws may not actually apply to every circumstance. And they're quite complex laws, and you probably need to get legal advice before you wanted to disclose any information if you were concerned about criminal prosecution. So whether or not we want to put that kind of onus on our medical practitioners who are speaking out for the good of the public is a question that needs to be asked. So at the moment, no prosecutions have been made under the secrecy laws because, as I say, they've only been introduced on the 1st of July this year. So it's really not clear the force of their powers. So I can't really give you any comments or insight into how these laws are actually going to work in practice because it hasn't been tested by the courts yet. But the situation at present is the fact that these laws exist will deter some medical practitioners from speaking out about what's happening in detention centres. And of course it needs to be noted that issues of secrecy existed before the Border Force Act. So things like contracts of employment will always specify that employees aren't allowed to disclose any information from within detention centres. There's also lots of stories out there about how much pressure is put on employees that work for the government in these centres to not disclose any information. So just one example of that, a lady named Nicole Judge in a Senate investigation into the Manus Island riots, she stated in her submission that I have been repeatedly informed of consequences of informing the Australian public of any operations performed at either centre. I have been threatened with the prospect of facing jail time and investigation by the Australian Federal Police if I speak out about incidents, events, handling of any relation that has occurred during my employment. So that's also quite concerning, and it makes you question why the government does want such a high level of secrecy around these centres. Like I said at the outset, the fact that we have mandatory detention and have these detention centres in the first place is quite concerning. There's been a bit of media attention at the moment that likens, especially offshore detention centres, to Guantanamo Bay and to the torture that is suffered there. And some connections were made between the government's policies of offshore processing and the Guantanamo Bay that's run by the American government. So things like moving a centre offshore, which limits transparency, and the fact that the government has a range of actors or contractors involved in controlling these centres, which diminishes the government's accountability. And then on top of that, you've got the secrecy issues, which I've just sort of talked about, the idea that the public shouldn't know what's happening in these centres. Even the fact that we have now prohibitive fees for journalists going to these centres so that, again, the public doesn't know what's going on. And there's a professor from Curtin University who's done an interview with the ABC just recently, and she makes the point that in America, George Bush's view when he was the president was that it was not torture if there is an organ failure or death. So he said that any action is fine and not torture until someone suffers organ failure or death. And this professor makes the point that it's quite worrying that in our Australian detention centres there are examples of people who need medical treatment but they don't receive it. They're not transported to Australia until they're at the point of organ failure or death. And this professor uses the example of a young lady in August was raped and subsequently was suffering in a catatonic state, and she wasn't transferred to Australia until she was on the point of kidney failure, so organ failure. Of course, there was also the tragic case of the 24-year-old Iranian man who suffered septicemia, and he wasn't transferred to Australia until he was actually brain dead. So these kind of events are quite worrying. But I didn't want to finish my speech without saying something positive, because there has been a few positive movements over the last few months in particular. So I just wanted to bring those to your attention and encourage you to keep learning about what's happening in our immigration centres and keep bringing a voice to this situation. So one thing that's happened recently is Clive Palmer. He's come out and said that abuse and torture is happening in Manus Island and Nauru, and he's actually set up a fund to pay for legal costs if any detainees there wanted to make a court case about how they've been abused. So that's, again, just one way of raising awareness. And then recently the Labor Party and the Greens have voted together so that a Senate committee will look into the treatment of asylum seekers also the transparency surrounding the offshore centres and the compliance with Australian and international law obligations. So this Senate inquiry will take place over the next year and a bit, and it's due for a report by the end of 2016. So that's another good development. Also this week, the ABC reported that a Labor backbencher by the name of Anna Burke has basically said that we've used people and asylum seekers as a political football and as an election winning process. So that, again, that recognition is something. And then the Liberal backbencher Russell Broadbent, he's foreshadowed softening public opinion on asylum seekers, and he points to the resoundingly positive reaction to the government's decision to resettle 12,000 extra refugees from Syria. So I guess what I wanted to leave you with is that the more public opinion changes on asylum seekers, the more movement we're going to see from our political leaders. So thank you for coming tonight and being interested in this cause. I think it's really important that the Australian people engage with this issue and learn as much as possible, and also pass that information on to your social networks and your contacts, because the more people that hear about what's happening in detention centres, the more movement we're going to see from our political leaders. Thank you.